So, California Attorney General says judge recognized Uber and Lyft's bogus argument that drivers prefer independence. He just released this today. California judge who ordered Uber and Lyft to begin classifying drivers as employees recognized the bogus argument that drivers prefer being independent contractors, independent workers, said California Attorney General. Becerra and 3 California city attorneys sued Uber and Lyft this year, alleging they broke California's new law that aims to secure benefits for gig workers by classifying them as employees. Now, I think Javier Becerra is missing a component here, and that is drivers would like to be true independent contractors. Right now, we are not independent contractors if you look at the way the companies are handling us. I understand the state wants money. I understand that the state wants to push them to the direction of employers being employers. But here's the thing. Here's the golden opportunity that Javier Becerra needs to seize, right? He needs to make the argument that they are not true independent contractors. He needs to make the argument that they are not getting the privileges that employees are getting, right? And he needs to steer them in the direction of meeting in the middle and creating a new gig hybrid law that incorporates both true independent contractorship and elements of what employees really get, right? So to me, a little bit dangerous to come out with this type of wording, may alienate some drivers. A judge granted a preliminary injunction Monday requiring Uber and Lyft to classify their drivers as employees. Within 10 days, the companies said they would appeal. The California judge who ordered Uber and Lyft to begin classifying drivers as employees saw straight through the company's bogus argument that drivers prefer the flexibility of being independent workers, according to California Attorney General Javier Becerra, who brought the lawsuit against the rideshare companies. In an interview with Squawk Alley on Tuesday, Becerra agreed with the prior day's decision. On Monday, a judge granted a preliminary injunction requiring the companies to reclassify their workers as employees within 10 days. What worker doesn't want to have access to paid sick leave, Becerra said? What worker doesn't want to have unemployment insurance at a time of COVID-19 crisis? What worker doesn't want to know that they'll get paid for overtime if they work 60 hours in a week or 12 hours in a day? He was asking. Now, he's right on all of those questions. Those privileges that everyone has should be automatically built into this new gig hybrid law, right? It should be in there. But you cannot come out and stamp a driver as an employee, right? Or as a semi-independent contractor, right? If you want to have true independent IC status, ladies and gentlemen, you get to choose your destination. You get to choose when you drive. You set the rules, you set the rates, you choose whom you want to work for, right? That currently is not happening. Uber and Lyft are pretending that you are a true IC, but you're not, right? So both sides really need to meet and hash it out. And more importantly, both sides need drivers at the table, right? You need representatives from all of these cities, San Diego, San Francisco, LA, Inland Empire, Orange County, you name it, Monterey, San Luis Obispo. They all need to be at the table and have their say, right? It's not that just the state can rule for the drivers without really knowing and understanding what the driver wants. And the same thing goes for the company. The company can't just come out and make these crazy statements that these drivers are already independent contractors when they're not, right? Becerra and 3 California city attorneys alleged Uber and Lyft broke California's new law, Assembly Bill 5, right? Uber and Lyft its framing of workers' classification as a trade-off between flexibility and benefits is a false choice, Becerra said in the interview. Let's take those words, flexibility and benefits, right? They shouldn't be a trade-off, right? They should not be a trade-off. They should both be combined into a new package, right? Got to bring the benefits in there, and you got to leave the flexibility in there, right? I think that should rather be his wording. You don't have to give up those rights and those benefits to have flexibility, he said. There's nothing in California law that requires a company to remove flexibility in order for these people to be classified as employees and get those rights. An Uber spokesman objected to that argument in a statement Tuesday. It is illogical to presume that if Uber were required to classify drivers as employees, we would not also be forced to set up the exact same structures like mandatory pre-scheduled shifts as every other company that depends on an hourly workforce, the spokesman said. This is why in nearly every survey over the last decade, gig workers have consistently said they preferred to be independent. And contrary to what the Attorney General said this morning, we don't think what drivers actually want is a bogus argument. So when you hear both sides, I still realize that they are far apart, right? They have their language and these guys have their language. There has to be a meeting and a common language, a new language, right? It just cannot be this way or this way. And I hope that they start communicating and trying to figure out, again, incorporating drivers in the decision making, right? Lyft did not immediately respond to a request for comment. Uber CEO Dara Khosrowshahi has recently advocated for what he calls a third way. Now, this third way is the right way, right? It's what we call sort of a hybrid. It's just that very late in the game now that he's afraid, now that, he knows the legal walls are coming down on him, he's adopting our language, right? But if we can truly find this third way, a combination of both, we should come out victoriously, right? It's just that Dara, who I don't think can be trusted, has never used this language, right? He's using the language now because it's really coming down on him. It's raining, storming, hailing, and he's got to cut a deal. So what do? We have this way, that way, let's find the third way. Well, if you are creating the third way, we have to be part of that decision making, right? It cannot just be two parties hashing out a third way. There is one important party missing at the table, namely the driver, namely the gig worker. Becerra characterized the push as a convenient policy position for a company that has consistently opposed reclassifying its workers as employees. Now, he's right on that. It's exactly what I just said, right? So their sudden push is suddenly convenient to them right now, right? But prior to that, their actions were completely the opposite. Uber and Lyft's actions were completely the opposite, right? So now suddenly this third way happens to be convenient. Well, you have them by the BALLS. So now try and leverage this third way, right? Why is it that it takes more than 10 years and a lawsuit for two innovative companies to come up with a new idea on how to provide the employees with the benefits that they're entitled to, Becerra said. There's nothing that's stopping Uber and Lyft from providing these benefits right now. He's right. So that, to me, is the correct wording, right? That is the correct argument. Where were you for 10 years? What did you do for 10 years? Why now? Why all of a sudden now? The way Uber and Lyft classify workers has become an even bigger subject of debate during the pandemic. With ridership down, many drivers who typically earn substantial income from the apps were left without a safety net, though they were ultimately covered by unemployment benefits for independent workers granted in the CARES Act. Now that's the taxpayers that have taken care of the drivers, not Uber, not Lyft, right? The taxpayers have paid in, and that CARES Act was really paid by taxpayers, right? By you and I. Becerra said he wasn't concerned about the potential for Uber or Lyft to leave the state if forced to pay their drivers as employees. Any business model that relies on shortchanging workers in order to make it probably shouldn't be anywhere, whether California or otherwise. So he's playing hardball, good for him. I just think that Javier Becerra should use the opportunity, should seize the opportunity to try and sit down with the companies and hash out this true third way. And again, drivers and gig workers have to be at the table, Javier. Have to be at the table, Dara. Have to be at the table, Logan Green and John Zimmer. Why not?